She hasn't received a dime of her money. He now owes her $108,000.
I haven't seen the kids in 3 years. Why is she doing this at this time?
She's already owed that $108,000. Mr. Sowers is buying time so that he can get more money. I don't care, with all due respect.
This matter is before the court this morning on the plaintiff's motion to compel sale of real estate. Parties have conferred this morning with Mr. Pratt from the front of the court, who has provided the court with the following recommendation: that the property listed at 6253 West Newburgh Road, as well as the property at 6357 West Newburgh Road in Carlton, shall be sold in order to pay the agreed upon settlement amounts. Ashley Sowers shall provide a apostille. I'm not sure what that is, for 6253 West Newburgh Road. I'm not familiar with that term.
Did you want me to address that, Judge?
Further, it says in the event the home is refinanced prior to sale, Mr. Sowers can maintain the properties. Yes, that's the recommendation. Ms. Zgorski, can you explain what's APPOSTILE?
Yes, it's effectively an international notary. Because my client is in Canada, a simple notary isn't enough. And she had to do that before. When she was in Mexico, she got an apostille. It's like a higher security seal.
Okay.
And of course, Your Honor, she is required to do whatever is necessary to cooperate to effectuate the terms of the judgment, and she will. She has in the past, and she will again.
Okay, so Ms. Sowers is still residing in Mexico, correct?
She's in Canada, Judge.
Oh, in Canada. Okay.
Yep.
So she needs to sign some documents for the West Newburgh Road properties. Is it still jointly held?
No, she quit claimed her interest over a year ago, and we learned today that what she signed a year ago apparently isn't sufficient. I've not seen any documentation. Judge, just to put it on the head of a pin and make it really simple for you, that you signed a judgment in December of last year that required Mr. Sowers to take certain action. And as I've set forth in my motion, she hasn't received a dime of her money. She was awarded $10,000 in January. She still doesn't have it. She was awarded $18,162.50 in March. She still doesn't have it. And next month, she's supposed to be paid $80,758.09. We don't have any confidence that she'll see that money either. Mr. Sowers is in arrears on his child support. But at any rate, you entered that judgment in December, and since then, there has been no communication on this issue between the parties or, quite frankly, counsel. I reached out to Mr. Petrangelo when his $10,000 check bounced that he made in January untimely. And since that time, I filed my motion March 22nd. I've not received a response to my motion. I've not received any proof of any attempts to refinance. I've not received any requests for her cooperation. So to the best of my knowledge and to the best of my client's knowledge, since this judgment entered, Mr. Sowers has done nothing. To the extent that he would present himself today and say that he has, I have no verification of that and no confidence that it's true. And I question his credibility. So that's where we're at today.
Right. Thank you, Ms. Zgorski. And the court did thoroughly review all the pleadings. I'm aware of all those facts. And so you're asking the court to adopt this recommendation, Ms. Zgorski?
I am.
Right. Mr. Petrangelo.
Yes, Your Honor. My client is actively trying to refinance these properties. What I did receive is a April pre-approval letter on one property, that being 6357 is represented. I can acknowledge that's not clear to me from this, but it does indicate on that property he's able to pull $55,546 out. He advises, and that's with Mutual of Omaha. He's been dealing with Rocket Mortgage trying to get this done on the other property. He indicates that if that goes through, he'll have more than enough to cover all of these things that are represented. There is apparently some problem with the notary on one of the deeds, because it was clear from all the documents and the judgments that she was out of the country, and yet the notary says it's a notary acting in Virginia. So I think that's raised some questions, and I'm not saying they won't provide us whatever we need to get that taken care of. That's not the real issue. I am suggesting that if we're going to proceed with a sale, it would be fair and appropriate to have realtors come look at the property to get us some recommended pricing, because we're not just going to pick numbers out of the air, and then select a realtor and move forward. I would think we could do these things simultaneously, at least that far. Give him some time to try to complete his refinancing, have the research and information done to know what we would have it be listed for and with who when we come back. And the judgment says you may order the sale of one or both properties. You have the discretion to act in that regard. I'm just saying the common sense, fastest way is to proceed on both tracks, get the information so we could list, give him the time to close. And so that would be the real distinction I have with the recommendation, is that we should secure information from some realtors so that it could be listed, and let him proceed with the refinancing and give us a date to come back. I know my client would like longer, but I think reasonably 60 days to close on financing. And then this, if he closed on one and he had most of the money but not all, for example, the court would look at those things. If he hasn't done anything, I'm sure you're going to say, okay, you've had your extra time. Now we know the realtors. Now we know the amounts. Here's what I'm going to order. But I don't think right now you could pick a figure and be fair to both parties. So I think that's just a reasonable way to accomplish what we're all seeking to accomplish.
May I
Mr.
respond?
Petrangelo, this recommendation appears to provide for that. It does not specify a time frame in which it must be listed. It simply says that it must be sold. So obviously, Mr. Soward needs to move quickly and yes, contact realtors, get fair market analysis, and decide to choose what realtors you list with. But the court would agree we should schedule a review date, because in fact, if we don't move it on this, the court's going to appoint a receiver. And that's going to be an additional expense, Mr. Soward's. Mr. Soward's has an obligation to pay Ms. Soward's $18,000 some dollars by March 22nd. That's past due, correct? You know, he owes another $80,000 on June 22nd, a month from now. So yes, and this recommendation says that if he can refinance in the meantime, fine. But again, this recommendation does not specify a time frame for that listing, and perhaps it should. So maybe what the court will do, in lieu of setting a time frame today, is to set this matter for review in 45 or 60 days. Mr. Zgorski, because then the judgment does not provide any interest on these obligations, does it?
It provides 10% per annum for the real property settlement, and I don't think it does for the personal property. The 18,162.50 was for personal property. The 10,000 that's overdue and the 80,000 next month are on the real property, and they're at 10% plus the cost of enforcement and attorney fee, which would be attorney fees and the motion fee, of course. My concern is that in 45 days, Mr. Sowers won't have done anything. So I would like him to secure a realtor now and get it listed. I think any realtor would set it at the highest possible price the market would bear. The realtor is going to want to make the most commission.
Right. Mr. Sowers has known about this obligation for at least 6 months. And he should have had that refinancing well underway by now, Mr. Petrangelo.
I would indicate to the court, he's advised us, he's been working on this since December on the various properties. The problem with the deed, he has indicated, cropped up to delay one. I just think, yes, of course, anytime someone's behind, they should have acted faster.
Well, it's not, there's no expense to Mr. Sowers to list this property. Any reason why the court cannot order that, should not order that he lists these properties within 30 days? I'll give him plenty of time to interview realtors and have the realtors get fair market analysis.
The problem with that, Your Honor, I think there's maybe a financial liability if you list it and the realtor comes back with a buyer after the closing, trying to get that accomplished. I would ask if the court would consider direct him to have this listed in 60 days. And that gives him his time to get the financing, time to secure these things, and that's a reasonable time. If he can't get it done in 60 days, then it's going to be on the market.
Well, but he's
Judge-
had 6 months to refinance, Mr. Petrangelo, and another 60 days to refinance. He's had plenty of time to do that. But this recommendation does not provide any time frame for listing the property. So what the court's going to do is adopt a recommendation to set this for review in perhaps 45 days. And if in fact it's not been listed, the court will most likely appoint a receiver. I'll see if Mr. Godfrey is willing to act as receiver if it's not been listed.
And that would be at Mr. Soward's expense.
Absolutely.
Jim, we need the apostille, even if it gets sold.
They understand there's a requirement that they provide any documentation needed for us to make this transfer, and but just get me the directive, and I will pass that to Ms. Zgorski, and we will, if they hold us up from there, we can tell the judge.
We will not.
We're talking
I'm
about
sorry,
6253 only, correct?
Both.
Whatever
Both
you have a
parcels.
problem with.
Both parcels are to be listed. It doesn't specify time frame, Mr. Soward, so you've got some time, but I'm gonna set this for review in about 45 days. And there's no reason why it should not be listed. And of course, if you get refinanced in the meantime, then you can cancel the listing.
I did begin refinancing immediately in December, but I have a letter from Rocket Mortgage indicating that I had to pay the
I
delinquent
object, Your
property.
Honor. I object. It's hearsay. His letter from Rocket Mortgage has not been introduced. I've never seen it. I object.
I sent a copy of that to Jim and submitted that already.
All right, if Rocket Mortgage wants, if they're not moving timely, you need to look at some other mortgage companies. Mr. Sowards and the realities maybe need to liquidate, one or both of these properties. So the court's can already list both properties for sale. There's no time frame. I'm gonna set this for review in about 45 days. There's no reason why it should not be listed within that time frame. Mr. Zgorski and Mr. Petrangelo, we have either July 2nd or July 3rd. I know it's close to the holiday.
Either one's fine.
The second would be the best day.
We either have 9 a.m. or 1:30.
How about 1:30 on the second?
Jim, the children are supposed to be here at that time. I haven't seen the kids in 3 years. Why is she doing this at this time?
Well, it's not her, it's the court saying this. When will the children be here all summer?
No, for the month of July, I haven't seen the kids in 3 years, and the
Okay,
timing of
all right.
this is obviously very
Okay.
not.
How about June
accurate.
28th then? We'll review June 28th before the kids get here.
Judge, I'm not in town on June 28th.
27th?
Yes.
We'd want to interfere with Mr. Soward's time with his children.
Okay.
Ms. Zgorski available on the 27th, which is a Thursday.
What time do we have? Can we do it in the morning?
Yes, the morning is good. You said June 27th in the morning? That's good.
Okay, how about 8:30? I'm not sure what I have at that time, but we'll make it work.
Okay,
That's fine.
Okay, so Ms. LaPrade, if you could kindly just add that to the recommendation that the court will review status of the listing on June 27th, 2024, 8:30 a.m.
Yes, sir.
Thank you. All right, anything further than this morning, Mr. Zgorski, Mr. Petrangelo?
No, Your Honor.
no,
What if
thank
I
you.
can provide the financing is going to be the fastest, easiest way to get it settled.
Okay,
If I can
hopefully you'll have
provide
that,
that-
you have some documentation that you've been approved for that when we come back on the 27th.
Okay, that's all I
And then-
needed was the apostille. We would have already had this settled if I had the apostille. Your
You
Honor.
need to be calling those mortgage companies every day, Mr. Sowards. They need to move on this like real quick. We need to have some definitive movement and payment on that by the June 27th.
Yeah,
So if
yes,
the
Your
court's
Honor.
not satisfied, the risk is the court's going to appoint a receiver.
If I can show you an approval by that date, will that be sufficient to proceed in that?
I'm not going to commit to that right now, Mr. Sowards.
Okay,
Approval that you may close in 4 months or after, you have a delinquent significant obligations that need to be addressed. So maybe reach out to other family members or friends. Maybe you can secure some other financing of other means so you can pay these obligations.
yes, Your Honor, and that's was part of
Oh.
the marital debt that I was required to pay as part of the judgment.
Keep on with the refinancing, but also reach out to realtors, get realtors and have do fair market analysis. You need to work both tracks at this time, Mr. Sowards.
Yes, Your Honor.
All right, that will conclude this hearing. You can all zoom out. Have a good rest of the day.
Thank
Thank
you.
you, Your Honor.
Thank you.
What about the apostle?
Part of the record.
Ms. Sowers will provide that.
Yes, we will.
Again,
Okay, all right, you can zoom out.
Thank you, Your Honor.
thank
You're
you.
welcome. Record this matter is before the court for the purpose of reviewing outstanding issues, which is primarily the status of the sale of real estate, in particular, the property known as 6253 Newburgh Road, Carlton. This hearing is being conducted via Zoom. Present is Attorney Maria Zgorski, representing the plaintiff, Ashley Sowers. Ms. Sowers is present. In addition, Attorney James Petrangelo is present, representing the defendant, Adam Sowers, and Mr. Sowers is also present. Good morning, everyone.
Morning, Your Honor.
When we were last in court on June 27th, the court entered an order that the property known as 6253 West Newburgh Road should be listed for sale on or before July 5. Defendant will provide a copy of the listing agreement to plaintiff's attorney immediately, and defendant will provide photographs of every room in the house where the children will be staying prior to July 1st, and the review hearing will be scheduled for today. The parties have conferred with Ms. LaPrade this morning, who has provided the court final recommendation, noting that the house is not currently listed for sale and that the receiver be appointed to forthwith sell both properties. That is 6253 Newburgh, and the other property, I believe, is 6357 Newburgh, in order so that the defendant can pay settlement payments to the plaintiff per the judgment of divorce. That's the recommendation. Mr. Petrangelo.
Your Honor, first of all, as to the sending the pictures, we did that. The children did come. They did have their visit. It was the first time in 3 years. My client's thankful all of that was able to occur. Appreciate everybody's involvement in that. As to the home, he did sign a listing agreement. The realtor is the realtor who they used when they first bought the property. He is with a firm, a reputable firm, and I believe Ms. Sowers knows that. That's not the issue. She's not getting her full support and her other money, and I understand that. We got the realtor on the line, essentially, and I'm paraphrasing what I heard, is that his opinion is that there were some major things to get done before this could be effectively sold, and not taking the time to get that done first could delay actually getting this marketed and sold. This is a property that had numerous trailers, dumpsters, junk, water issues, all of these things. He has a date set up next Tuesday to come out and take photos, to now post it on the multi-list, and he confirmed that his expectation is the property, if that's all done as he's directed, should sell quickly. Now, this case is scheduled to come back on August 28th at 8:30 on an objection filed by Ms. Zgorski. Anyway, I am requesting that the court delay appointing a receiver or consideration of that until that date. As much as I understand the need to get these things paid, we've got numerous photos showing an enormous amount of work that's being done, and people have come out as volunteers to help Mr. Sowers get this property cleared. This is not me asking for 6 months. I think we'll see where we'll have a much clearer idea where we are in just 3 weeks. So with that, I don't see a receiver working much faster than that, really, in the effect of getting the property sold. So that my client, I think, thought there were going to be buyers coming out. The realtor explained that he has other realtors who'll come take a look also, and my client viewed that as a showing coming up. That's not a showing in terms of buyers, but it is clear that people who they're going to have a good view as to how marketable this is to sell, and that's the point of it. And that's I think that's a sound plan of action and not an exorbitant period of time in consideration.
What is the nature of the objection hearing on August 28th at 8:30? The court was not aware of that.
I'll address that. Thank you, Mr. Petrangelo. It's my objection. Your Honor, Mr. McKee had Mr. Sowards on his show cause docket, and Mr. McKee was adjourning, and the last time he adjourned based on Mr. Sowards' representations that he was selling this house and would be able to pay his arrears. Mr. Sowards is over $16,000 in arrears on his child support. I objected to Mr. McKee's recommendation, and so that show cause is now on your docket with Attorney Hicks. That's what's on for the 28th is the show cause.
Is it on this court's docket?
Yes, I coordinated with Attorney Hicks. In fact, I reached out to her this morning. She explained that I was to put it on your docket. I provided her with a notice of the hearing and Mr. Petrangelo and Zoom instructions to you, and she said she would pick it up from there.
Thank you. And obviously, Ms. Zgorski, you're asking the court to appoint a receiver forthwith, correct?
Judge, I don't know what else to do. I filed my motion to sell this property in March. That was 5 months ago. Mr. Sowards has known of his obligations in the December judgment since they were negotiated last fall. You know, he now owes her $108,920.59 and he's not paying his support. He's not meeting his obligations. He said he was ordered to list the house by July 5th, and he didn't do that. He's not following any of your orders, and I don't know what else to do. He shows up today, and he wants more time, and he wants more time, and he wants more time. Time is up. You've already ordered this.
Court recognized that. Mr. Petrangelo, again, what needs to be done on this property? Just a junk needs to be removed, or does there need to be some repairs made?
All of those things, Your Honor. There was water in the basement. There needed to be repairs there. There's these two parcels had been treated as one, and things all there involved. He's provided me photos of these huge pillars, fencing being pulled out, of people emptying out these shipping containers on the property. This was scrap metal and things was part of his occupation, and this was used as a storage area. So there, he has provided me with photos showing a great deal of activity and others helping him. The Mr. Piper, the realtor, did acknowledge a lot had to be done and needs to be done. I think this is an issue of we got a realtor, he signed the agreement. He's trying to do what the realtor tells him will sell it fastest and most effectively, and we're on track in just next week to put it on, have the photos and put it on the multi-list at that point. So whether Mr. Sowards should have done it faster than that, when we're down to days, I think taking an extra step of a receiver is not necessary.
If I may,
So,
Judge.
Ms. Zgorski, have you received a copy of the listing agreement?
I did, Judge. The listing agreement existed the last time we were in court. That was done before. That's not some step that he's taken. And I always appreciate maximizing the sales price of something, but we're doing it at the expense of my client. She's already owed that $108,000. Mr. Sowards is buying time so that he can get more money. I don't care, with all due respect, about the profit that Mr. Sowards makes. My client's entitled to her money and has been for months.
All right, the court, we're going to give Mr. Sowards one last opportunity. The court's going to adjourn this matter to August 28th at 8:30. And the court's going to order Mr. Sowards personally appear that morning. Mr. Sowards, unless you made a significant payment toward your child support arrearages, there's a real good chance we're going to start contempt proceedings that morning. So you're to personally appear the morning of August 28th at 8:30, fourth floor of the courthouse. Mr. Petrangelo, you can appear personally if you wish, or you can appear via Zoom, but Mr. Sowards ordered to personally appear because we're going to proceed with contempt for fair paid child support. And at that time, if the property's not been listed on the multi-list, the court will in fact appoint a receiver. I can guarantee you that. So don't wait till the August 27th to do this, Mr. Sowards. Get it done.
Yes, Your Honor. I am actively doing that as quickly as possible. And
It's not quick enough, sir. It's been 5 months and month after month after month delay. So this is your last delay, Mr. Sowards. You're digging a deep hole for yourself, and you can the realtor can sell it while you're sitting in the county jail. So it's adjourned to August 28th at 8:30, the last adjournment, and the court will appoint, in fact, a receiver on that date. Ms. Zgorski, maybe you can, I don't know, who you propose. I know Attorney Godfrey has acted as a receiver in the past. Maybe Billy Jeffers may be a good candidate, but the court will in fact appoint a local attorney to act as receiver. And that will, of course, reduce any net proceeds of this sale, Mr. Sowers. So just so you're aware of that. And if you don't make some, if you need to come up with some cash payments to the front of the court between now and then in your child support.
Yes, Your Honor, I understand. And I just
I
like
will
to say
conclude this
that I was
hearing.
first actively
Thank you,
trying to
Your Honor.
finance it because I knew the sale would be a large project.
You need to borrow some money from family and friends, Mr. Sowers. We can't wait till the sale of this property for you to pay child support.
Yes,
One
Your Honor.
may be thinking in terms of property settlement payments, but child support needs to be paid.
I will do that,
So
Your
the
Honor.
court will in fact start contempt proceedings on August 28th at 8:30. We'll appoint an attorney to represent you. If Mr. Petrangelo doesn't represent you on that contempt. All right, the court, Mr. Pratt, if you could modify the recommendation, please. And we'll serve on then August 28th at 8:30.
Thank you, Your Honor.
Thank you, Your Honor.
Thank you, Your Honor.
Your Honor, the updated recommendation's already in your queue.
Thank you, Mr. Pratt.
She has not been able to work and will require the support of the defendant in the form of spousal support and child support. She and the minor child have no other place to go except for the marital home, but due to her inability to work, she is in need of the financial support of defendant to continue to pay the bills associated with the marital home, including but not limited to the mortgage, taxes, insurance, utilities, and other necessities of life such as gas, groceries.
She states that she has no money, but she spent $400, over $400 to change the lock on the property. And she put over $800 in cameras up.